Okay, I'm going to leave the class for a moment. Ah, thank you. Thank you, ma'am. Okay, because there's just no point in continuing the class if I cannot record it. Uh, it is an extra class. It's not necessarily a convenient time. But okay, I don't know what the issue was with my laptop. But let's get started. Don't want to take up too much of your time. Um, we're busy looking at the organs of a company. I taught you that a company has two organs: the shareholders, members acting in general meeting, and the board of directors. In our very first class, I pointed out to you that a distinctive characteristic of a company is the separation between management, ownership and control. Also, every time I said that, I did um, warn you that although I'm using the word control, it's not 100% accurate. I'll clarify all of that during this lecture. So then we looked last Wednesday's class at the shareholders in general meeting, the nitty gritty, the mechanics of how shareholders make decisions. So we're done with the shareholders now. In today's class, we're moving on to the other organ, namely the board of directors. Please remember at all times I'm speaking of the board as a collective, not specifically individual directors. Let me share my screen quickly. Okay, so company directors. Repetition slide there of what I've previously said, that you have the shareholders and then the board of directors. Issues that we're going to be looking at in this class is who is a director, what is the legal position of directors in a company, different types of directors, we get different types of directors, who may be appointed as a director, and how do you fire your directors, the removal of directors. So the definition of a director in the Companies Act is similar to when we started. We looked at how does the Companies Act define a company. And we saw that the Companies Act basically says a company is a company. Definition of directors in the Companies Act is similarly unhelpful. It simply states that a director is any person occupying the position of director or alternate director of a company. So that doesn't actually tell us much. What the Companies Act also provides is that every company must have directors. It is a statutory requirement. You cannot have a company without directors. On all official correspondence sent by the company, the names and nationality of the directors must be stated. All come from an accounting background. You've undoubtedly seen official correspondence coming from companies. It's normally a letterhead on top, and then at the bottom, there's a footer which states the names of the directors. Companies Act also provides that it is an offence to publish the name of any person as a director when he or she is not a director or has not been validly appointed. So those names at the bottom of the official letterhead have to be the actual directors that were validly appointed. Companies must also keep a director list, a register of their directors at BIPA. So you can always go to BIPA and check who the directors of a company is. It is also an offense to call yourself a director. Now, the term director sounds very fancy. People like calling themselves directors. It is also an offense to call yourself a director if you have not been validly and actually appointed. So if you've just been appointed as chief accountant, whatever, you can't go walking around wearing big earrings and saying, oh, I'm the financial director. Director occupies a very specific position in a company. It's not just a name for a type of employee. Now, the legal position of directors within the company is fairly unique. You get appointed as a director, but your appointment as a director does not automatically imply that there is a contractual relationship between the company and the director. Similarly, we've looked at the constitution of the company, and at that stage I already explained that directors do not derive any rights from the constitution of the company. Shareholders, members, derive rights from the constitution, but not the directors. A provision in the constitution stating that Sally will be a director forever is not enforceable. Directors are basically appointed at the will, at the behest of the shareholders, and the shareholders can also get rid of them. We're going to look at removal of directors. Despite this, shareholders can enter into a separate contract of directors. Directors can enter into a separate contract of employment with the company. So each situation, you have to look at the facts of that particular situation. Was there a specific contract, or was there simply an appointment? So with regard to the appointment of directors, I don't have a slide about that, but that's paragraph 3 of Unit 9. You can just look at that. Normally, the first directors are appointed at the time of registration, time of incorporation. In many instances, the subscribers, the first people that sign the memorandum, are also the first directors. And they will then hold office until the first annual general meeting, until such a time where their appointment will then either be renewed or they will be replaced. It is a common practice. Once again, it's not law, it's a common practice that a certain number directors are appointed or reappointed at a general meeting. it's a good practice to have a certain number retiring and being replaced, and another further number remaining on the board to maintain a sense of continuity. Those that remain will then retire the next time around and be replaced. So there are always some directors that have some knowledge, have some experience, rather than a whole fresh bunch of people coming in at the same time. And you get different types of directors. This is just terminology. Use the word alternate director, somebody that's been appointed, but they don't attend meetings regularly. They just sort of kept in reserve, so to speak, for if it could be happen that a particular director will be absent from board meetings for a lengthy period of time. Not talking about just missing one meeting, but if a director is going to be absent for a lengthy period of time, the alternate director will then step in during that period of time. A de facto director. De facto, Latin, it translates to as a matter of fact, rather than de jure, legally. A de facto director is a person who's not hasn't legally been appointed as a director, but is treated as such. This becomes relevant in Unit 11, no, Unit 12. Unit 12, when we do contractual liability of companies. So a de facto director, person who hasn't been legally, procedurally appointed, but is treated and acts as a director. This situation can arise if people act as director without having been properly appointed, or they were appointed, but there is some defect in their appointment or qualifications. I'm going to elaborate on that shortly. Then the most important distinction that you need to understand is the distinction between executive and non-executive directors. An executive director is an employee of the company. A non-executive director is not an employee. They merely serve on the board. The principles of corporate governance require that for public companies, there must always be a certain percentage, in fact, preferably a majority of non-executive directors. That's where we come in. What I've tried to explain previously is directors don't manage the company. The position of the board of directors is one of oversight. The managers manage the company, and the directors are there to ensure that they're doing a proper job. Your non-executive directors should not become operationally involved. They should not start giving day-to-day instructions. They need to have sufficient faith and belief in the actual management to let them do the job. They attend meetings maybe once a month, maybe even less than that, where the managers report to the board, and the board then checks that they've been doing. But once again, please remember, I'm talking about a public company here, not talking about a small private company where all the shareholders are also directors. There, the directors will do the day-to-day running as well. Talking about your public companies where terms of proper corporate governance, your board of directors must be one step removed. They should be the golden word here is independent. Your board of directors must be independent. They should not depend on the company for their day-to-day income. Because if they depend on the company for their day-to-day income, they might be inclined to ignore certain irregularities because they don't want to be fired. Whereas if they're independent, their income isn't at risk and they can put their foot down and say, no, what you're doing is wrong. Very, very important concept there. So back to de facto directors, person who's not legally a director, but who is treated as such. The irregular appointment of a director can be set aside. But now the question arises, how will this affect outsiders who dealt with this director, believing that this is a director, somebody who can validly represent the company? You studied the law of agency in Introduction to Law of Accountants, and you learned that if there is no authority, the agent cannot bind the principal. This would be a similar situation where if certain acts are reserved for directors, can only be done by directors. If somebody then does that act, which is reserved for directors, somebody does the act, but they're not a director, then legally that act will be invalid. You cannot do something that only directors may do if you are not a director. This can, of course, affect outsiders in dealings with a company where they believe they are entering into an agreement with a director, to subsequently find out, but actually this person wasn't a director, so the act was invalid. To provide for these some situations like that, the Companies Act provides that any act of a director is valid despite any defect in connection with his or her appointment or qualification that may afterwards be discovered. This means that it can be assumed that a person who appears to be properly appointed may validly act in that capacity. This provision will, however, only apply if there has been some form of appointment. Won't apply if Susie just one day randomly decides to call herself a director. Also not apply if there's been a fraudulent assumption of power, and it will only concern acts which were performed before the discovery of the irregularity. Once the irregularity has been discovered, that person needs to stop acting and they need to appoint a proper director. These provisions of the Companies Act in practice are not that relevant anymore, because there have been certain changes in Section 40 of the Companies Act that we look at Unit 12, which are actually easier to apply than these particular provisions. So who may be a director? There are two types of qualifications, rules that determine who may be a director or not. Firstly, we can refer to the share qualification. Now, the Companies Act does not provide that directors must be shareholders. It also does not apply that directors may not be shareholders. Common mistake that students make. If I'm referring to whoever Ryan is a shareholder and a director, you tell me, but there's a division in corporate functions. If he's a director, he may not be a shareholder. That's wrong. You may be a shareholder, and a company may, in its constitution, actually require directors also to be shareholders. Stipulate that in order to qualify as a director, you need to own a certain number of shares. That is what we mean by the share qualification. Companies Act does not state that you have to have it, but it does state that if the Constitution requires qualification shares for the appointment of directors, a person who is appointed as a director must obtain those shares within 2 months after having been so appointed. And they have to pay for these shares. They can't be gifted these shares. If after 2 months after their appointment they have not yet acquired these shares, they are required to step down as a director and may they not be reappointed until they have acquired the necessary shares. So you can't be appointed, not get the shares, step down, be reappointed another 2 months, not get the shares, blah, blah, blah. First time you're appointed, you're given 2 months to get the shares, to acquire the shares. If not, you need to step down and can only be reappointed once you actually have the shares. Then the Companies Act also doesn't say who may be a director. It states who may not be a director. Disqualification, statutory disqualification, which is divided into 2 types of disqualification. You get an absolute disqualification or a relative disqualification. Relative disqualification means that you can only be appointed as a director with the prior approval of court. So company wants to appoint you as a director and you're relatively disqualified, you must first get the permission of the court before you can be appointed. Absolute disqualification, quite easy. Firstly, a body corporate, a juristic person. Directors must be natural persons. They must be human beings. Cannot appoint a company as a director of a company. Also absolutely disqualified, a minor or any other person under legal disability. Somebody that does not have contractual capacity. In order to be a director, you need, or as part of your functions as directors, you need to be able to contract on behalf of the company. Obviously, you can't do that if you yourself don't have contractual capacity. And then, this is quite obvious, any person who is disqualified as a director by order of court. If you've previously been a director and you messed up, and the court, to such extent that the court in terms of section 226, gives an order that you may never again serve as a director, then obviously you are disqualified. Relative disqualification, unrehabilitated insolvent, this is all in the notes. All of this is in the notes. People, please, you cannot rely solely on the PowerPoint slides in order to pass the course. The PowerPoint slides are an outline. You need the actual study guide notes. They are on e-learning. Unrehabilitated insolvent, any person removed from office, from an office of trust, So anybody that had, yes, Hedwig, your hand is up.
Yes, ma'am. I would like to ask if about being disqualified. Now, if maybe let me say if I was working for a certain company, then I was disqualified. I messed up and then disqualified. Like I must never be a director. That means even in other companies I cannot be a director anymore, or how?
That will depend on the extent of the court order. But Section 226 basically relates to people that actually, I want to say, messed up so much that the court feels they should not serve as a director for any company whatsoever.
Okay.
So if you were a director of company A and you stole money, that type of thing, because it relates to really, really bad management, dishonesty. So you're a director of company A, you're a director of company A, company B, and company C, because you can have more than one directorship. Now, in company A, you mess up so badly, you're fraudulent, you steal money, etc., etc., and they apply for a court order prohibiting, banning you from being a director of any company. You will then, once the court has given that order, also have to step down from the board of company B and company C.
Mm-hmm. Okay.
These orders are very rare. The court will not just for anything. The court is very careful, and it considers all the facts before handing down an order in terms of Section 226. They won't just for a minor misstep give such a broad-reaching um, order that you may never again serve as a director. More common is where the one that I was just referring to, any person removed from an office of trust on account of misconduct. So you were on the board of company A and you were removed as director because of whatever you did. This can or would much rather lead to you to be relatively disqualified, which means if another company wants to appoint you, you need to get permission from the court. We'll look at all the circumstances. What happened? How many years ago was this misstep? Maybe you've since whatever changed your characteristics. I'm finding difficulty finding my words here. So a relative disqualification, you're told to step down, but that doesn't mean you can never, ever, ever be a director again. There you need to apply for permission from the court, and the court will take into consideration all the surrounding facts and circumstances. A disqualifying order is forever. Once you've been totally disqualified, that's absolute. And then the third relative disqualification, any person who has been convicted or sentenced to either imprisonment without the option of a fine or to a fine exceeding $1,000 for theft, fraud, forgery, or uttering a forged document, blah, 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 blah. That's quite a long sentence. Go look at that in your notes. I will not ask you to memorize that and write that down, but rather if I'm asking you if somebody may be a director, you should recognize essentially somebody that has been convicted and imprisoned or sentenced to a fine in excess of $1,000 for crimes involving dishonesty. So not for murder. The fact that you've murdered your husband doesn't disqualify you from being a company director, but having been convicted of stealing money. Remember, office of director, position of trust. And if you have a history of financial crimes, crimes involving fraud or dishonesty, obviously you can't serve as a director without the permission of court. It's a relative disqualification. The court will take the circumstances into consideration. Maybe this was 15 years ago and you've since been rehabilitated and not been found guilty. Then they'll say, okay, we'll trust you now. Now, how do we remove directors? In order to remove the directors, there are two procedures that are parallel. Directors can be removed in terms of the Companies Act. A particular company can also have provisions in its constitution stating the procedures to be followed if the company wants to remove its directors. Both these procedures are always available. The individual shareholders, the individual company can always decide, do we want to follow the provisions set down in our constitution, or do we want to follow the provisions set in the Companies Act? They have that choice. Whatever the company requires, the company in the constitution might require a special resolution or a unanimous vote or whatever, they can follow that. But there's always Section 228 of the Companies Act, which states that directors can be removed at any time by way of an ordinary resolution. You don't need, in terms of the Companies Act, you don't need to adopt a special resolution to remove your directors. Directors can be removed by way of an ordinary resolution, provided that special notice of the meeting has been given. Remember when we did Unit 8, when we did notice periods, I had a slide referring to notice periods. 21 days, annual general meeting, ordinary meeting 14 days, meeting for a special resolution 21 days, and then I had it highlighted there saying special notice. Special notice is 28 days. Special notice is required for a meeting that is to adopt a resolution removing directors or external auditors. The director in question, director standing, must be informed, must receive a copy of the notice, and is allowed to make written representation before the meeting and to be personally present and make representations, explain to the meeting why they should not be removed. Section 228, as I've already explained, states that these provisions apply, notwithstanding anything in its memorandum or articles or in any agreement between it and any directors. Emphasizing the fact that directors do not obtain the right, they do not obtain any rights as directors from the Constitution. If they have an agreement with a company, had it there, let's go up to this very first slide. We were talking about the legal position. I said they can enter into a separate contract. That separate contract cannot prevent their removal. Section 228 will override whatever is stated in that separate contract. But if there is a contract and they are removed prior or before the expiry of that contract, they would possibly have a claim for damages based on breach of contract. Claim for damages, not a claim for specific performance, not a claim that I must remain as director. But if they are removed prematurely, they could possibly claim damages. So removal of a director, either in terms of whatever the procedures are laid down in the Companies Act, in the Constitution, or Section 228 of the Companies Act is always available. 28 days notice, ordinary resolution, simple majority, 50% plus one. The director must be invited to the meeting and have the opportunity to speak. And then directors' meetings, we don't do this in detail. Company can have its own procedures, determine its own procedures for meetings, but there is a statutory requirement that they must keep minutes of every meeting. Directors' meetings and decisions must be minuted. Don't always have to have a physical meeting. Also have a written resolution where it's sent by email and everybody just says whether they agree or not. It's also known as a round robin resolution. Directors can also act by way of unanimous assent or unanimous consent, where there was no formal meeting, no formal minutes, but they are all aware of the fact and everybody agrees. Okay, questions about this? Any questions about this? Let's move on to Unit 10, the duties and liabilities of directors. Duties and liabilities of directors, we are referring to the common law duties. To share my screen again.
Sorry, Miss, before we proceed, do we have
Yes.
a question bank?
Come again?
Do we have a question bank?
What do you mean by a question bank?
Let's say a sheet with various questions of what one can expect.
On the website, e-learning platform. I must just go and check exactly where it is, because it seems some students are finding the e-learning platform a bit difficult to use, because if you log onto e-learning, it appears as if there's nothing, but you need to click on the links. There are worksheets. I'll go and find them and just send a screenshot of where you can find them. There are worksheets, company law worksheets that I have uploaded on e-learning that contain sample questions and not model answers necessarily, but guidance as how to answer these questions. Please,
Okay.
when you are preparing specifically, not so much, yes, they're also useful for the online test, but not so much. These are, because online questions have a different format. They're multiple choice, fill in the missing word type of thing. These workshops are worksheets, very valuable for preparing for face-to-face testing and exams, where you have case studies, longer questions, structured questions, where you have to write sentences. Sometimes I give a model answer, sometimes not necessarily a model answer, but just guidelines. Look at this, you have to address this, you have to address this. Please do download those and use them. They are there for you to use. Okay, duties and liabilities of directors. not referring to the specific duties of a specific board of a specific company. Because there, of course, it will differ. Talking about the common law duties that apply to all directors, irrespective of what company board they are on, what the nature of the company is, whether they are executive directors or non-executive directors, whether this is a private company or a public company, these duties will apply. Sorry. Okay, so the contents there. So where do directors' duties come from? From if they are employed, if they are an executive director, from the employment contract, from the company's constitution. Companies Act contains plenty of duties for directors, filing annual reports, etc., etc., etc. And then the common law duties. These are the ones that we are looking at in this particular unit. So the duty of good faith. You immediate reaction should be now, oh, but we know all about good faith. That's why introduction to law for accountants is a prerequisite for company law. You did. The duty of good faith isn't a duty which is unique to company directors. It is a duty that anybody has. These people are known as fiduciaries. Person who has control over the assets of another or holds the power to act on behalf of another. Remember, the shareholders own the company. The directors have control over the company, control over the assets of another. They stand in a fiduciary position, not unique to companies. Lots of people have a fiduciary duty. Partners, directors, trustees, members of close corporations, etc., etc. It can be summarized in brief, namely that a director stands in a fiduciary relationship to his or her company to act in good faith. Typo? Fix my typo? To act in good faith and to avoid a conflict between his or her interests and those of the company. Same as in partnerships. Act in good faith and avoid a conflict of interest. Question that can be asked: can a director contract out of these fiduciary duties? Not just the fiduciary duty, also the duty of care and skill that we will be looking at in shortly. Companies Act states expressly that any provision in the articles or stipulation in the contract which purports to exempt a director, officer, or auditor of a company against any liability towards the company which would normally result from their negligence, default, breach of duty, or breach of trust is void. So you cannot agree to become a director and say, but okay, I'll become a director, but I want a contract that says that if I do something wrong, you will not hold me liable. That is not possible. You cannot contract out of your common law duties. So we've already done in partnerships, we already looked at the fiduciary duties. When it gets to directors, I'm essentially saying things that I've already taught you, just using more words, different words, but it's essentially the same duty. When dealing with directors' fiduciary duty, we tend to divide this duty into 4 categories. But these categories aren't cast in stone, and a certain wrongdoing can often fall in more than one of these categories. So don't let this confuse you too much. These categories, they should prevent a conflict of interest. They may not exceed the limitations of their power. They must maintain an unfettered discretion and should exercise their powers for the purpose for which they were conferred. The duty to prevent a conflict of interest has certain rules have been crystallized regarding the conflict of interest rule. The duty to prevent a conflict arising between your own interest and those in the company, known as the no conflict rule. You may not make a profit from your fiduciary position, the non-profit rule. And you should not usurp any contract or information that belongs to the company and keep it for yourself, known as the corporate opportunity rule. We discussed all of these when we were doing partnerships. Now we're just adding fancy names to them. In instances where there was a conflict of interest, the same as partnerships, not only can the company claim damages from you, but they can also hold you accountable for the profit. If you made a profit, a personal profit, contrary to your duty to perfect a conflict of interest, the company can claim that from you. On page 55, I'm not going to go through it now, but please do read through that. On page 55 of the notes, I give some examples based on actual court cases, which illustrate the no conflict, the no profit, and the corporate opportunity rule. These are interesting facts. Go and read them. They will clarify what I mean. I seem to have a repetition of slides here. Okay, that is a duplicate slide. The duty to maintain and exercise an unfettered discretion. Unfettered discretion might sound like big words. What do these words mean? To fetter something literally means to tie something up. You've been riding a horse and you get off the horse and tie the horse to the tree. You fetter the horse. And then when you untie the horse again, the horse is now unfettered. Same with your discretion. Objectivity. A director must always base their decisions on what is the best for the company, not as what is the best for them or what is the best for whoever they are representing. Sometimes shareholders, specifically majority shareholders, maintain the right to appoint a certain number of directors to represent them or their interests on the board. But even in these circumstances, when the director is called upon to make a decision, they must decide what is going to be best for the company, not what is best for whoever shareholders they are representing. If outside parties appoint directors as puppets, as in, okay, you're going to be serving on the board, but you don't get a say. I'm going to tell you every time what you have to decide, what you have to vote for. That can actually be considered fraudulent. This is actually quite the concept of maintaining an unfettered discretion, acting objectively in the best interests of the company and not subject to the dictates of somebody else. Concept is easy to understand. In practice, it can become quite tricky about how to make a decision if the decision is better for the company, but actually worse for the people that you are supposed to be representing. Duty to exercise the powers for the purpose for which they were confirmed. They shouldn't have a hidden agenda. Let's say, for example, the constitution of the company states that directors have the right to issue shares. Now, why does a company issue shares? Company issues shares to increase its share capital. Directors may decide that they need to increase the company's share capital and issue shares. But on the other hand, what about a situation where the directors are actually unpopular and they realize that at the next general meeting, the shareholders are going to remove them? So what do? They issue more shares to their buddies to increase or to change the balance of power amongst the shareholders so that they have their buddies there as shareholders and they won't get voted out. A hidden agenda, essentially. That is also a breach of fiduciary duty. Yeah, okay, so sorry, I've done all of those now. Just getting lost on my slides here. Effective resignation on fiduciary duties. Directors' duties, most duties, once you resign as a director, your duties end. That's obvious. But certain fiduciary duties will continue. This is the same. This is nothing new that I'm teaching you. We discussed this when we did partnerships, so you should already understand this. The fiduciary duty will continue where the competitive activities continue. You cannot resign, step down, or avoid your conflict of interest by resigning from the company. It will continue after you. Same as a partnership. You cannot dissolve a partnership in bad faith in order to avoid your fiduciary duty. Contracts between a director and the company. We don't do this in great detail. A director may, just so in summary, a director may contract with its own company, provided there is no conflict of interest, provided it is done at arm's length, openly, and that the company, the shareholders are informed that the director actually does have an interest in this company. Personal liability towards others. Director can be held personally liable for the debts or liabilities of a company incurred during such period when business of the company is carried reckless or fraudulently. We don't really do that. Statutory personal liability, if the company lost money as a result of the director's actions, the company will have a claim against that. I seem to be missing a slide here. Just give me a second. That's the slide that I missed. Sorry. That's why I was a bit confused now. So we've finished now with the duty, the fiduciary duty, the duty of good faith. Another important duty is the duty to act with care, skill, and diligence. Similar, once again, to partnerships. A duty of care, a duty not to be negligent. As is the case with partnerships, the law takes the fiduciary duty very, very, very seriously. And there are, just give me a second, please. Okay, sorry. There are countless court cases dealing with the duty of care and skill. Sorry, I'm distracted. There are plenty of court cases dealing with the fiduciary duty. Not so many with breaches of care, skill, and diligence. Because the standard of care, as is the case with partnerships, is not that high. Breach of the duty of care and skill will be a delictual claim. The standard of care that is required is question that is asked is, did the director act in a way that a reasonable person would have acted under those circumstances? So no particular qualifications or specialization is required. Knowledge and experience of a director must be imputed to any other reasonable person in the circumstances. Factors that will be taken into consideration is the nature of the company's business, or if a director professed specific skills. So if I'm appointed as a director due to my legal knowledge, obviously the expectation would be that I have specialized legal knowledge, and I won't be compared then to just anybody that doesn't have that knowledge. But otherwise, duty of care and skill, not such a demanding duty. Fiduciary duty, very important. So essentially, that's it. This is a repetition of what we did when you did partnerships. Just some new words. But I hope that was clear. Thank you for making the effort to join the class on a Sunday morning. We will have a revision class then on Wednesday. Thank you. Bye.